Laws.com.
Filing for divorce in Maryland. Step 1. Determine eligibility. Before filing for a Maryland divorce, you must ensure that you meet the state's residency requirements. These regulations, which largely revolve around the location of the grounds for dissolution, must be adhered to before filing. A judgment of divorce will not be granted by a Maryland court unless the filer or defendant has resided in the state for at least 1 year if the grounds for divorce occurred outside of the state. If both spouses are residents of Maryland, the spouses may file for dissolution in the county in which either resides. If the couple is filing for divorce under the grounds of insanity, Maryland divorce law institutes residency requirements of at least 2 years. Step 2. Deciding the appropriate divorce. Maryland offers couples 2 divorce options, an absolute divorce and a limited divorce. Couples wishing to dissolve their marriage completely should file for an absolute divorce. To file for this divorce, the filing spouse must prove the existence of an acceptable ground such as desertion, adultery, 2-year separation, and cruelty of treatment, insanity, conviction of a crime, or voluntary separation. If granted, the court will decide on child custody and alimony issues. However, inheriting property from your spouse is not permitted under an absolute divorce. If you lack the funds for divorce, or if you or your spouse cannot agree on the divorce settlement, you should file a limited divorce in Maryland. This form of Maryland divorce is a court-supervised separation and must be filed in the county where you reside. Under this Maryland divorce, the spouses may inherit property from one another, but legal proceedings will determine the division of property, health insurance coverage, and child custody. Step 3. Filing and serving. After filling out the appropriate forms, you must file them with the clerk of court where you have initiated the dissolution. After review of your documents, the clerk will stamp and file the forms. Once filed, your spouse must be served by a process server or the county's sheriff. When served, your spouse is given 30 days to answer the complaint. If a disagreement arises with regards to the proposed settlement, your spouse can initiate a formal hearing in the court of law or alternative dispute arena.
To watch more videos, please make sure to visit Laws.com.